Hi students, I welcome you once again to this class on business law, and in this video we'll be looking into legality of object and consideration. So once you complete this video session, you'll be able to understand the various cases in which object or consideration of an agreement is unlawful. What is an object or the consideration in an agreement? So here we see that the term object means the purpose for which the agreement is entered into between the two parties. Also, consideration, as we know, is the payment or the reward in any agreement. Here we see that the object of an agreement and also the consideration of an agreement needs to be lawful. Wherever the object or the consideration is unlawful, the agreement becomes void and it cannot be enforced in the court of law. According to the definition here, Section 23 of the Indian Contract Act 1872 provides that the object or consideration of an agreement is unlawful under the following cases. These are 6 cases in which the object or consideration is unlawful. So first one is if it is forbidden by law. Second one, if it defeats the provisions of any law. Third one, if it is fraudulent. Fourth one, if it involves or implies injury to the person or property of another. Fifth one, if the court regards it as an immoral object. And the sixth one, if it is opposed to a public policy. So let's see some of the examples for these cases. Number one, if it is forbidden by law. If the consideration or object for a promise is such that if it is forbidden by law, the agreement becomes void. It is illegal and cannot become valid even if the parties act according to such agreement. Some of the examples are: A promises to B that he would obtain an employment for B in the public services, and B promises to pay rupees 1000 to A for that. This agreement is void as the consideration for it is unlawful. Here the consideration is that A has promised to B that he would obtain an employment in the public services. So that is the consideration here for B, and rupees 1000 is consideration for A. So obviously the consideration is unlawful and so the agreement becomes void. Also, we'll see another example. X sells liquor without license to Y. This sale is void as the sale of liquor without license is forbidden by law. In every state of India, we have different rules regarding selling of liquor. So when we take Tamil Nadu, for instance, only the government agency, which is TASMAC, has the license to sell liquor. So no private player can sell liquor other than TASMAC. So we can take the same example as here. So if someone sells liquor without license, obviously that agreement becomes void. So number two, if it defeats the provisions of any law. So if any object or consideration of an agreement tries to defeat the provisions of any law, the agreement becomes void. For example, here A let a flat to B at a rent of rupees 1200 rupees a year. To reduce the municipal taxes, he has entered into two agreements with B. One, by which the rent was stated to be rupees 450 only, and the other by which B agreed to pay rupees 750 for services in connection with the flat. So what has happened is B, after agreeing to pay rupees 750 for services, he has not paid that amount to A. So in a suit filed against B to recover rupees 750, it was held that the agreement was made to defraud the municipal authorities and was void. So A cannot recover the money. So what has happened here is A has tried to defraud the municipal authorities by stating that he has been receiving only rupees 450 as a rent for the flat, wherein he has received rupees 1,200 a year. Number three, if it is fraudulent, agreements which are entered into to promote fraud are void. Some of the examples are: A, the agent for a land proprietor agrees for money without the knowledge of the principal to obtain for B a lease of the land belonging to his principal. So the agreement between A and B is void as it implies a fraud by concealment by A on his principal. So what has happened is A, the agent of the principal, as was trying to lease out a land of his principal to B for some money. So obviously this agreement has become void because it is an act of fraud. We'll also see another example. A decides to sell goods to B and smuggle them outside the country. So this is a fraudulent transaction, and so it has become void. Now B cannot recover the money from A. Number four, if it involves or implies injury to the person or property of another. The object or consideration of an agreement will be unlawful if it tends to injure the person or property of another. Some examples are: a contract to publish a book that is a violation of another person's copyright would be void. This is because the consideration here is unlawful and injures another person's property, that is his copyright. Second one, an agreement to pull down another's house is unlawful. Third, X agrees to pay Y rupees 10,000 if he damages the property of Z. So in these cases, the agreement becomes void. Number five, if the court regards it as immoral. When the consideration or object of an agreement is such that the court regards it as immoral, the consideration becomes void. For example, A lends money to B to obtain a divorce from her husband C. It was agreed once B obtains the divorce, A would marry her. When B does not obtain the divorce and also does not give back the money, A approaches the court. But the court passed the judgment that A cannot recover money from B since the contract is void on account of unlawful consideration. Number six, if it is opposed to public policy. So we have seven kinds of objects which are opposed to public policy here. So number one, trading with the enemy. Entering into an agreement with a person from a country with whom India is at war will be a void agreement. For example, a trader entering into a contract with a Pakistani national during the Kargil war is a void agreement. Second one, stifling prosecution. For example, A agrees to sell land to B if B does not participate in the criminal proceedings against him. So stopping someone from participating in the court proceedings. Number three, maintenance and champerty. A maintenance agreement is when a person promises to maintain a suit in which he has no real interest. Also, champerty is when a person agrees to assist another person in litigation or court case for a portion of the damages or proceeds. In these two cases, also it is against the public policy. Next, an agreement to traffic in public offices. For example, A promises to obtain an employment for B in the public services, and B promises to pay rupees 1,000 to A. So this is against public policy. Agreements to create monopolies. For example, an agreement not to bid at an auction sale comes under opposed to public policy. Next, agreements in restraint of a marriage. For example, an agreement to stop a marriage is opposed to public policy. And finally, interfering with the courts. An agreement whose object is to induce a judicial or state officials to act corruptly and interfere with the legal proceedings is opposed to public policy. So to summarize, an object or consideration in an agreement is unlawful if it is forbidden by law, if it defeats the provisions of any law, if it is fraudulent by nature, if it involves or implies injury to the person or property of another, if the court regards it as immoral, and finally, if it is opposed to public policy. So thank you so much, students, for listening. I hope this video was really helpful to you. Please do subscribe to my channel and also share this video with your friends. Thank you.